Good morning. Welcome to our webinar, It's Okay to Say Gay in the Workplace, examining workplace issues for the 2S LGBTQIA+ community. While I introduce myself and our speakers today, please see the information slide that is on your screen. My name is Grace McDonell, and my pronouns are she and her. I'm an associate in Fasken's Vancouver office, and I'm part of our litigation and dispute resolution practice group. Today, I'm joined by Erin, a Toronto partner and vice chair of the Labour Employment and Human Rights Practice Group, Rhonda Grintuch, a Montreal partner in the Labour Employment and Human Rights Practice Group, and Jacob Wagner, a Toronto associate in the Labour Employment and Human Rights Practice Group. Today, as we discuss diversity, we'd remiss in not acknowledging the incidents of this past weekend in Buffalo and the impact that they have on the Black community and communities of color. At times like this, our voice and support matters. We need to be unequivocal that we stand against all forms of hate. One further note on setting the stage today. We all arrive here together today from different locations with different job titles, responsibilities, and lived experiences. It's important to recognize that we're all at different stages of our learning in this area. So let's set the tone for today. We're all learning. We must continue to learn. No one was born with this knowledge, but we're all meant to live authentically. Part of this includes understanding and supporting the authenticity of others. This is not just tolerance and acceptance, this is more. We must all create the space for the learning. With some commitment, effort, and listening, we can learn from each other. Often our fear promotes inaction. The fear of getting it wrong understandably exists, but it is our hope that today we can help you all take the next step. Now with that, let's set forth on today's learning. So this is our agenda for today in terms of going over the state of the law in the US, setting the stage for pronoun use, protected grounds, state of the law, harassment and discrimination investigations, and some lived experiences and recommendations. So the state of the law in the US, we often look to our neighbors to the south, and in these cases, here are a couple examples we don't necessarily want to learn from. So what's up in Florida? In March 2022, Florida's Republican Governor Ron DeSantis finalized Bill HB 1557 that prevents students in kindergarten to grade 3 from learning about sexual orientation and gender identity. Many supporters of this bill have said that it vindicates parental authority. So the law contained in this bill includes it as follows. Classroom instruction by school personnel or third parties on sexual orientation or gender identity may not occur in kindergarten through grade 3 or in a manner that is not age appropriate or developmentally appropriate for students in accordance with state standards. This law actually gives parents the rights to sue instructors, schools, third parties if their students and their children are learning this information, which we say is critical. The next example we have in setting the stage today is the unfortunate leaked decision, Dobbs and Jackson Women's Health Organization. So this essentially overturns Roe v. Wade, a woman's right to abortion, or an individual's right to abortion, I should say. And Justice Alito in this draft says only rights deeply rooted in the nation's history are recognized. And I want to read one additional quote today because I think it's especially important to this conversation. So Justice Alito says, while individuals are certainly free to think and to say what they wish about existence, meaning, the universe, and the mystery of human life, they are not always free to act in accordance with those thoughts. I think a lot of what we're talking about today involves the existence and how we identify and how we express that identity. So in terms of our limit on expressing our existence, as mentioned, this decision is particularly scary and something to keep in our minds today. And we have at the end of this slide is Obergefell next, and the passage I just read to you 2 paragraphs later, Obergefell, which allows for same-sex marriage in the United States, is actually mentioned. So something to keep in mind. And for certainly in Canada, we are not immune to this type of discrimination. Just some statistics to put for you today. Since 2019, there's been a 40% increase in hate crime against the 2S LGBTQIA+ community, half of those being violent crimes. In terms of economical hardship, the annual average income for LGBTQ individuals is 39,000 versus their non-LGBTQ2SA+ community members being 58,000. So just some numbers and some statistics to keep in the back of your mind. Now, in terms of setting the stage for pronoun use, first to look to the legal profession and the law. Over the past few years, courts across Canada have been all making efforts to de-emphasize gender and the use of gender language. From 2019 to the British Columbia Court of Appeal, as well as most recently in November 2021, courts have issued practice directives mandating that all court participants, that includes counsel, that includes witnesses, that includes parties, anyone entering the courtroom, must provide their correct pronouns and their correct form of address. And we'll get into the difference between correct and preferred language in a little bit. But most recently, there's been the removal of your ladyship, your lordship, my lady, my lord. In addition to being gender inclusive language, it's also, those terms, if you may not know, are based on colonial roots. So all efforts to support reconciliation as well. As far as I'm aware too, and I did do a bit of research, those practice directives, as well as being issued in Ontario and I believe Nova Scotia, but first they did occur in British Columbia. They're first of its kind in the entire world. So definitely something to learn from in terms of what this country and these provinces are doing. So the goals of these practice directives are to improve the gender diverse parties and lawyers' experiences within the legal system, correctly identifying pronouns and forms of address, and to have one equal application. The effort is to avoid misgendering and avoid making assumptions about based on name, appearance, voice, especially, in the COVID era of attending things via phone call. You don't necessarily see that person. So it removes that opportunity to just make assumptions. Moving forward as well, so in terms of the interaction of gender pronouns with professional responsibility obligations, there has been an argument made that these practice directives or asking others to provide their pronouns or their correct forms of address is compelled speech. In terms of the legal setting as well, I think it's practically speaking, we can translate this to other forms of how we interact in the world. Court decorum has always been a thing. We're told to wear gowns, where to stand, the concept of bowing, how to refer to our colleagues, swearing or affirming testimony, answering COVID screening questions nowadays, passing through metal detectors. So there's a number of things that we're asked to do. This is just one additional step, and it promotes inclusivity, and it promotes not making these assumptions that I've referred to. Wanting to avoid misgendering someone is not new. We can think of many examples where someone leaves a coat and you say, oh, they left their coat. You don't know who that person is. So it's just kind of unwinding those societal, kind of connections that we've made in our head that are based off of what we assume. In terms of human rights and pronouns, there's a connection that's been made. Jake's going to get into this a little bit, but protections have been codified for gender identity and gender expression. Pronouns aren't a matter of preference. We should be referring to them as correct pronouns or just pronouns. Expressions of others' identity, as I mentioned, is a protected ground. And there's been a lot of research, especially recently, into the costs associated with misgendering someone intentionally or unintentionally as well. It's a microaggression and it negatively impacts mental health and physical health. There's a heavy emotional burden and stress associated with constantly having to correct someone about how you identify and who you are, and shame associated with deciding not to correct, especially in a professional environment. No one wants to interrupt whatever is going on, especially in a professional setting, and say, you know what, you're wrong. This is how I am to be referred. There's also a lack of physical, psychological, or social feelings of safety, and that contributes to significant barriers to access for justice above and beyond those that already exist. And just one thing on how we wish to be referred to each other. We think about how the reasons behind why we potentially might change names, marriage, divorce, that basketball player who changed his name to Meta World Peace. Often we don't blink twice at those types of name changes or differences in our life. But the amount of respect that you give someone should not correlate to the reasons behind why they want to be referred to. So we should all be respecting those for how they tell us they wish to be referred. A little bit of pronoun 101 here. So what's the easiest way to ask someone what their pronouns are? Well, it's to share your own. As I mentioned at the very beginning, I'm Grace, my pronouns are she and her. What pronouns do you use? That also indicates that you're welcoming of a gender identity and expression, and often others will see that you are potentially a safe space, and they will be comfortable with being who they are. So, and in terms of language, the words we use relationally, language is relational. They can make a massive difference to someone's existence and to be feeling seen and heard. I think language is meant to make us bloom and be expansive. And so, in going along with that, in terms of accidentally misgendering someone, it's okay to make a mistake. We started off at the beginning trying to create that safe space. The best thing that you can do, correct yourself. Don't exude your feelings of potential embarrassment or shame. It's not about us. It's about, who we're relational with. Don't dwell on feeling bad. Just correct yourself and keep going. I can assure you that is what the other person wishes as well. And below here on this slide, we just have different pronoun options and how to use them. It's important to remember that these can be used in combination. Pronouns, gender identity, gender expression are fluid. So, there could be a change. I thought that this person wanted to be referred to as this, and now they're saying this. The best thing to do is to ask and to be sure that you're using the correct pronouns. And on the next slide here, we just have a glossary of terms as well. I think we all know what gender expression is, but there's a number of ways we can express who we are, how we are, the way we dress, talk, it's all included here. One other note in terms of transgender or trans being an umbrella term used to describe people whose gender identity is different than or doesn't conform to the norms prescribed for people of the sex that they were assigned with at birth. It's transgender, trans, not transgendered. That's a key one to remember. There's non-binary as well, another umbrella term used to describe gender identities that are not exclusively male or exclusively female. This also includes potentially agender as well. And then cisgender is one that comes up a lot, refers to a person whose gender identity corresponds to the sex they were assigned at birth, also known as cis. And just to toss another one on there that I get asked about a lot is dead naming. So dead naming someone is using the name that a person no longer uses. So we want to avoid dead naming. We want to ensure that we're using the correct name, the correct way to refer to a person. And then in terms of transitioning, steps like that, the term that's most appropriate to use is gender affirming or, gender affirming surgery, gender affirming steps, all a part of allowing someone to be seen. They're affirming who they are. And then here on this slide, we just have a couple inclusive terms. I think I drafted this. I may have never used howdy folks before, but I've definitely used hey folks. We all say guys, hey guys, best thing to do, hey everyone, folks, be inclusive in that way. And just kind of one further slide on our own pursuits in this avenue, because I think that's very important to know what we're doing here. In January of 2021, Fasken introduced our own pronoun policy, which permitted all staff and lawyers to add pronouns to signature blocks to normalize conversations around gender. In addition to the pronoun policy itself, there was a resource guide and a number of links as well. We're constantly updating that as we add more pronouns and the ways in which we refer to each other are ever evolving. And this just contributes to creating a safe workplace and removes not having to guess. And I'm going to toss the baton over to Jake to go over the protected grounds.
Thanks so much, Grace. So in the protected grounds, there's various legislations that outline these grounds. Federally, it's the Canadian Human Rights Act. In Ontario and British Columbia, it's the Human Rights Code. And then in Quebec, it's the Charter of Human Rights and Freedoms. There are other provinces that have legislation, obviously, just not noted here. And they all show the different protected grounds against discrimination. And so if we could just go to the next slide, which outlines these grounds. So you'll see in the jurisdictions, there's a lot of overlap between the provinces and federally, race, national and ethnic origin, color, religion, age, and sex. But for the purposes of today, we're really focusing in on sexual orientation and gender identity and expression. There are also other interesting ones, federally genetic characteristics, and in British Columbia, Indigenous identity and ancestry, which is often within race and national ethnic origin. If we could just go to the next slide. So here in Andrews and Law Society of British Columbia, a 1989 Supreme Court decision, the court defined the term discrimination. It's not technically defined in every jurisdiction, but I think this is a very useful guide for us. I just want to point you to two important aspects of this definition, and it's whether the distinction is intentional or not. And I think going back to Grace's point about microaggressions, it's really important. We often view discrimination in the macro level, something that is so heinous and so egregious that it is obvious that it is discrimination. But there are also tiny microaggressions, and as we'll see in the case law, little pet names or misgendering, misusing pronouns are these forms of microaggressions that over time can really build up and create, a toxic work environment and really affect the person that's on the receiving end of it. And then the second part is the imposing of burdens and obligations. So it's not necessarily about creating identical treatment. It's about equity and ensuring that everyone is got a seat at a table and is able to feel that they are able to participate and be themselves in any place, and the workplace especially. So if we could just move on to the next slide. These just outline some of the discriminatory practices, the denial of goods and services, facility and accommodation. It's important to note that, refusing to employ someone based on their gender expression and identity, is prohibited, or treating someone unfairly because of that. And that unfair treatment, can take many forms, from, the overt to the covert, and everything in between. And so I think as employers and managers, it's important to really keep an eye on the workforce and see what's going on interpersonally between folks, to ensure that everyone in the workforce feels that it's not just, the majority rules all the time, and that everyone feels protected and safe. There's also the following of policies or practices that deprive people of employment opportunities. And again, the unequal treatment and compensation based on gender, race, sexual orientation, and identity, as well as membership in unions, trade, or professional associations. And just going back to unequal treatment and compensation, there's pay equity legislation. And again, when we look at that pay equity legislation, it's male and female, and again, doesn't look at the whole spectrum of gender expression or gender identity. So again, there's always points of learning and ways to make things better, but this is a starting point. And then finally, when we look at systemic and individual discrimination, systemic discrimination is a little bit more subtle. Usually we can find examples of this in established practices or policies that would lead to an adverse impact to someone in an equity seeking group. And then individual discrimination, again, can be very obvious on that macro level, or can be microaggressions and small little issues that come up over time. And so the state of the law in Canada, the use of pronouns and workplace transitioning at work. We'll also focus on dismissals a little bit later in Rhonda's presentation. But if we look at the leading cases, We have Nelson and Goodberry, which is from the BC Human Rights Tribunal, and Vanderpuden and Seiko Packaging, a little bit older case from 2012. But again, both these cases highlight how important it is to ensure that people feel safe at work, that they're respected at work, and that management is taking a proactive step at ensuring the health and safety of all of their employees, regardless of where they lie and their gender identity. And so in Nelson and Goodberry, we have a server. If we could just be, oh, thank you so much, Andrea. We have a server named Jessie Nelson, a non-binary, gender fluid, transgender person. Their pronouns are they, them. During their employment, a bar manager by the name of Mr. Global would continually misgender and use female pronouns, as well as nicknames, including Pinky, because Jessie had pink hair, Sweetheart, Sweetie, and Honey. And this may seem on the surface to be, not that important and something that one should just shrug off. But after repeated attempts asking Mr. Global to stop, Jessie became defeated, felt othered, and again, just was completely demeaned. It was just a form of disrespect, and it continued to get worse and worse over time, even though Jessie had asked several times for it to stop. And I think there's a quote from the tribunal decision where Jessie states, "It's incredibly dysphoric feeling. I've lived my entire life attempting to self-express and figure out who I am and find a place in this world. And I've worked very, very hard and gone through a lot to get here. And it's a challenging battle to have on a daily basis, even when people don't mean it, and let alone when someone's doing it purposely." And I think going back to Grace's point where, accidents happen and it's not perfect, but showing willingness to learn and to do better goes a long way. But when you're purposely doing this and trying to demean something, then that's when it becomes, a form of discrimination that you can't ignore. And unfortunately, in this case, management did ignore it and thought it was an interpersonal issue. They had spoken to Mr. Global, but didn't do a proper investigation, didn't take all of the steps necessary to ensure that Jessie's complaints were heard. At a staff meeting, Jessie brought forward their complaints, again, very bravely, and that was met with a lot of resistance because some folks understood where Jessie was coming from and other folks didn't. And so in the end, it blew up into a huge fight between Jessie and Mr. Global, which led to Jessie losing their job and being terminated. And so the tribunal was faced with three questions. Was this discrimination? Was the employee's response reasonable? And was Jessie's gender identity and expression a factor in their termination? And so the tribunal first considered whether Mr. Global had discriminated against Jessie. And so the use of female pronouns and gender nicknames to demean Jessie led to this poisoned work environment and this lack of respect. And so this constituted discrimination and violated Jessie's gender expression and identity under the code. And then the second question, was the employer's response reasonable? And so in looking at this, the tribunal looked at whether the bullying and the misgendering of Jessie was discrimination and fell short of the reasonable expectations of an employer to do something about this behavior. This lack of urgency, the shrugging off of complaints, and the lack of investigating these really valid concerns all led to the tribunal really finding that, Jessie had been discriminated against and that their response was poor. So it's not about just passively taking action, but really proactively seeking that there is change. And finally, was Jessie's gender identity and expression a factor? Most definitely. This whole incident occurred because that Jessie was misgendered. The pronouns were not properly used. And again, this bullying behavior of Mr. Global just created this toxic work environment where Jessie could no longer be themselves, feel safe, and continue to do their job. And so moving on to the next slide, why does Nelson matter? And so respect is the name of the game. I think everyone, deserves respect. And in Jesse's case, all they wanted was to be considered, by their pronouns and to be treated as an equal. And that just wasn't happening by management or by Mr. Global. And then, as I've said before, an employer has a positive duty to ensure the health and safety of all working in their environment. This is a proactive duty. So ensuring that complaints are investigated, that every reasonable measure is taken, and being proactive, seeing how people are interacting in your workplace are all super important factors. And then finally, small little nicknames or comments, can grow into something much, much bigger and lead to a major workplace conflict. So they shouldn't be ignored. These microaggressions should be really taken care of at the outset. And when employees come to you, saying that these are microaggressions, that shrugging it off and saying they're little nicknames, it is important to take this seriously because it can grow and become worse. And so moving on to Vanderpuden, a little bit different here. Ms. Vanderpuden underwent her sex reassignment surgery while working at Cideko, so from male transitioning to female. And she alleged in her application that she was subjected to a poison work environment and was dismissed because of her gender identity. And so on the next slide, we see that Ms. Vanderpuden claimed she had asked to have her shift times modified, an accommodation, so that she could change in private while she transitioned. She was also harassed by male staff members since she was not permitted to use the female change room. So both that accommodation was not provided and she was forced to use a male change room. And then she was also publicly ridiculed on a work bulletin board. Now, the facts of this case are a bit contentious because there were some also workplace and performance issues going on with Ms. Vanderpuden outside of these claims. But the tribunal really took everything in context here and understood that the pressure and the harassment that was ongoing by her male colleagues in a factory setting was really what was leading to a lot of these issues and led to discrimination under the code. And I would just like to note that, change rooms we'll discuss a little bit later in the physical space section of our presentation. But for folks for the 2S LGBTQIA community, it's very difficult. I think there are some, hard lessons from childhood where, you don't feel safe in a dressing room and it is very difficult, or a washroom. And it's important to really take notice of these things if that's in your workplace and remain sensitive to people's past experiences. And so the tribunal reviewed whether the applicant's treatment during her employment and subsequent dismissal were violations. They found that they were both harassment while working, and then that the dismissal was due to the harassment. It was clear to the tribunal that the company Cideko didn't really review their policies in the sense of helping Vanderpuden really transition and feel accepted and safe. Again, back to the obligation under the code, one must be proactive and really, really focus on ensuring that everybody is protected. The tribunal noted that transgenderism within society at large also plays a factor into this and in workplaces, and that a lot of folks just don't have the education or the tools to know how to help others who are transitioning or what to do. And I think, this is a great first step of educating yourself and learning about ways you can help the community and those that are transitioning. And I think starting now and putting in policies in place now will help head off, a lot of the concerns that the tribunal noted in this case regarding a proactive approach. And so it's just some notes and lessons from Vanderpuden. Workplace culture really does matter. Little comments and, little microaggressions here and there can really pick at people. And looking at the makeup of your workforce is also important. You know, is it highly dominated by, you know, cisgendered males? Is it, you know, a diverse workforce? All things to consider when looking at your policies and how to engage with your workplace culture. Again, educating the workforce on 2S LGBTQIA issues is super important. Next month in Ontario is Pride Month, so it's a perfect opportunity to really engage with things that are ongoing in the community. There are a lot of folks that, you know, do this for a living, love to chat about, you know, ways to improve things, and could be a great opportunity to have employees who are not normally, you know, exposed to these types of issues or concerns really learn something and take away something and have a more lived experience. And then finally, as I said, the time is now to really put these policies in place, whether it's a transitioning at work policy or a pronoun use policy. You may have employees that are afraid to transition or don't feel comfortable coming forward. And so these policies can really, you know, make dividends for those people, and maybe they feel comfortable in their workplace to actually come forward and transition. Or, you know, you may not have anyone part of the 2S LGBTQIA community, but a welcoming policy may allow people to, you know, enter your workforce, enter your employment, and want to be part of the team. And so I think it all just starts with welcoming people and respecting people. And so I'll just move it over to Rhonda now.
Thank you. If we can move to the next slide, please, Andrea. Thanks. So I will take you through 3 cases this morning that involve dismissal and complaints for dismissal on the grounds of sexual orientation or gender identity. 2 more recent cases out of BC and another older case from Ontario that I think still has some important implications and lessons learned for employers. If we could go to the next slide, please, Andrea. Thank you. So in the first case here that I'm going to be discussing, Conklin versus UBC, the complainant was, Mr. Conklin was an academic advisor for the UBC Faculty of Arts. The university terminated his employment for cause on the grounds that Mr. Conklin's profile on various location-based gay male dating or hookup apps was a conflict under the university's conflict of interest policy. And to get more into the weeds here, on one app, for example, he identified himself as an employee of the university, but he didn't use his real name. There was one example that the university provided of a screenshot which showed his location at a university residence. And when questioned by the university on his participation in these apps, he admitted that he had had hookups with students in the past. The university explained its concern that this could constitute a conflict under their conflict of interest policy, and that by Mr. Conklin identifying himself as a university employee on the apps and engaging in romantic or sexual relationships with students on social networks, that was the crux of their concern and constituted a conflict under the policy. Mr. Conklin here voiced that he understood the university's concern, but disagreed that this amounted to a conflict of interest. And what was actually interesting here was that the university did not have any specific policy that explicitly prohibited relations between faculty and staff and students. So in this case, the university, after having a series of meetings with Mr. Conklin, eventually moved to termination for cause. Next slide, please. So the complainant filed a complaint against UBC alleging discrimination in employment on the basis of sexual orientation, contrary to the BC Human Rights Code. And here UBC applied for essentially a summary dismissal of the complaint, which occurs before a hearing takes place. The criteria that UBC had to demonstrate was that there was no reasonable prospect that Mr. Conklin's complaint would succeed at a hearing. The decision of the tribunal was that UBC had shown that there was no reasonable prospect that the complaint would succeed, and so they dismissed the complaint at that level. Mr. Conklin then applied for judicial review of the decision, which centered on the question of whether Mr. Conklin's sexual orientation was actually a factor in UBC's decision. And the standard here on review was one of patent unreasonableness. Next slide, please, Andrea. Thank you. So the tribunal, at the tribunal level, the decision was based on whether the evidence demonstrated that there was no reasonable prospect of proving, of Mr. Conklin proving that his sexual orientation was a factor in the adverse treatment. And the tribunal did indeed find that there was no way for him to establish that he was not using his position as a member of the university staff to advance his status with students in a way that was of personal benefit to him. The tribunal found that the evidence demonstrated that the university's legitimate and non-discriminatory concern here was to prevent employees in positions of trust from having sexual relationships with students. Next slide, please. So in order, at the judicial review level, Mr. Conklin had to prove that his sexual orientation was indeed a factor in UBC's termination of employment, and that the decision at the prior level was patently unreasonable. When the court looked back to the tribunal's decision, they found that the tribunal was sensitive to various arguments that Mr. Conklin had made regarding stereotypes. The tribunal said that they were sensitive to the fact that UBC was likely reacting to various behaviors or statements that were made on the apps through a heteronormative lens. But that the tribunal is also sensitive to the fact that gay men have historically been and continue to be subject to pernicious stereotypes about the way in which they express their sexuality. However, the tribunal found that the evidence does not suggest a concern that the university would have had a concern about Mr. Conklin behaving in any sort of predatory way, or in any manner that otherwise invoked negative stereotypes about gay men. Rather, the evidence revealed that Mr. Conklin either knowingly or foreseeably commingled the population that he was charged to advise in his role at the university with the population that he sought to hook up with. The tribunal also stated in the decision that they have taken considerable time in contemplating Mr. Conklin's arguments and reviewed Mr. Conklin's evidence in light of stereotypes. However, in all the circumstances of the case, the tribunal is not convinced that there was anything more to Mr. Conklin's complaint than conjecture to support an inference that his sexual orientation was actually a factor in the university's decision to terminate. And at the judicial review level, the court ultimately dismissed the application after a careful review of the tribunal decision. The court determined that the evidence demonstrated that the university's concern was legitimate and non-discriminatory, and that it was primarily concerned with preventing employees who were in positions of trust from having sexual relationships with students. The tribunal also found that, or the court also found that the tribunal's conclusions were sufficiently grounded in the evidence before it in order to satisfy the criteria of patent and reasonableness. So the judicial review application was dismissed. Thank you, Andrea. So the next case here, the Bedre and Rain City Athletics file. This was a decision from 2019 before the BC Human Rights Tribunal. The complainant here, Mr. Bedre, was employed as a fitness coach at Rain City Athletics. The respondents were aware upon hiring Mr. Bedre that he was a gay male. About 3 years after he was hired, Rain City terminated his employment. This was in 2017. Mr. Bedre then filed a complaint with the BC Human Rights Tribunal and claimed that sexual orientation was a factor in the decision to terminate him. He also made the complaint on the basis of mental disability that played a lesser role in the decision. If we can move to the next slide, please. So Mr. Bedre alleged that he experienced abusive conduct, repeated bullying, homophobic, and other inappropriate comments from the respondents early on in his employment, and that it occurred on a regular basis. The respondents on their end denied discriminating against Mr. Bedre and alleged that they received negative feedback from clients about the complainant's rude and abrasive behavior, and that was in fact the reason for termination. So the termination here was performance-based and had nothing to do with his sexual orientation. Mr. Bedre's evidence involved examples of having encountered apathy by the owners of the fitness center on various discriminatory issues. So he also stated that there was a lack of adequate response, for example, to the use of racial slurs by a Rain City fitness coach. There was resistance to LGBTQ inclusive projects such as gender-neutral bathrooms and fitness classes exclusively for members of the LGBTQ community. And on the other hand, the respondent's position was that Mr. Bedre's employment was terminated because of the ongoing performance issues as a coach. They cited examples of rude and abrasive behavior, of bad-mouthing clients, of bullying coaches, and insubordination. They also demonstrated evidence that of regular negative feedback that they received from clients against Mr. Bedre, and evidence that clients routinely avoided Mr. Bedre's classes due to his lack of skills as a fitness coach and his rude and abrasive behavior. Next slide, please. So ultimately, the tribunal's decision here turned on credibility. The tribunal found that the respondent's evidence was reasonable, it was internally consistent, and it was consistent with the evidence of other witnesses that testified at the hearing. And the respondent's evidence was also consistent with the documentary records. On the other hand, Mr. Bedre was found by the tribunal to not be a credible witness because his evidence was often vague, it was lacking in particulars, it was self-serving in certain instances, and overall was not consistent with the contemporaneous records that existed at the time. So even though Mr. Bedre was suffering from a known mental disability at the time of his termination, and as I mentioned earlier, the fitness center was aware that he was of his sexual orientation, there proved to be no relationship between those factors or his sexual orientation. The poor performance was prevalent throughout his employment, and the evidence demonstrated that and enabled the respondents to establish that there was a reasonable non-discriminatory explanation for the termination of his employment. Furthermore, there was no evidence that established that Mr. Bedre was subject to ongoing discriminatory harassment on the basis of sexual orientation. The tribunal did say that to the extent there were any comments attributed to individual respondents that were off color or inappropriate, even if they were made, they were not so virulent or inherently damaging to Mr. Bedre's dignity, so as to trigger the Human Rights Code protections. So ultimately, the tribunal dismissed the complaint. Thank you, Andrea. This is the last decision that I'm going to take you through. The OHRC versus Christian Horizons. This is a bit of an older decision, but I think that there was an important discussion in the decision on bona fide occupational qualification that we'll see in a moment. So this decision concerned an appeal of a decision by the Human Rights Tribunal of Ontario that went to the Ontario Divisional Court. Here, the employer Christian Horizons is a nonprofit, faith-based charitable organization, and they provide residential homes and care and support to Ontarians with developmental disabilities, regardless of creed. So all employees of the organization were required to sign a lifestyle and morality statement, as it was called, which set out various conduct that Christian Horizons deemed to be incompatible with effective Christian counseling ideals, standards, and values. Amongst other things, this lifestyle and morality statement prohibited homosexual relationships. Next slide, please. Here, the complainant, Ms. Heinz, was a resident support worker for the organization. So some of the tasks that she performed as part of her core duties were cooking, cleaning, and helping residents to eat. During her employment, she entered into a homosexual relationship. After informing her coworkers of her relationship, the treatment at work and her work environment became intolerable. She eventually went on mental health leave and resigned from her position. Here, what was interesting to note was that the complainant self-identified as Christian. If we could skip to the next slide, please. Thank you. So the 2008 decision by the Human Rights Tribunal of Ontario found that Christian Horizons did infringe on the rights of an employee who was in a same-sex relationship. The issue in question in the decision was the right of Christian Horizons to require its employees to sign the lifestyle and morality statement, which prohibited employees from having homosexual relationships, and more generally, the right of a gay employee in the organization to be free from discrimination in the work environment based on sexual orientation. So at the appeal, Christian Horizons conceded that its conduct or its treatment of Ms. Heinz in employment was contrary to the Human Rights Code. But their argument was that their conduct came within an exception under the code. The exception is under Section 24, where they had to demonstrate 3 criteria in order to benefit from the exception. And the exception here essentially held that the right to equal treatment is not infringed if the organization can prove that it was a religious organization, B, if it is primarily engaged in serving the needs and the interests of people identified by their creed, and employs only similarly people who similarly identify, and C, if the restriction in employment to persons similarly identified by creed is a reasonable and bona fide qualification because of the nature of employment. So we refer to that as the BFOQ requirement. Next slide, please. Here, what was interesting was that the decision essentially turned on the BFOQ requirement. The court allowed the appeal, but on other grounds, so it was allowed in part. But the court came to the conclusion that the appellants had failed to establish a bona fide occupational qualification that was reasonable in the circumstances. The ruling found that Christian Horizons was unable to prove in the circumstances that avoiding a same-sex relationship was a valid occupational qualification for the position at hand, so for the position of support worker. The court stated that while the support workers maintain a general Christian culture in the home, like Ms. Heinz did, by engaging the residents in prayer and Bible reading. They were not hired, nor were they expected to bring the residents into the evangelical Christian religion by having them adopt a certain lifestyle. So essentially, there was nothing about the performance of the tasks of a support worker, which were essentially cooking, cleaning, doing laundry, helping the residents to eat, wash, use the bathroom, taking them on outings and appointments. There was nothing inherent to those duties that required an adherence by the support workers to a lifestyle that precludes same-sex relationships. So the court's decision on this BFOQ requirement is consistent with existing jurisprudence that we've seen over the years. The qualification, because it's an exception to human rights legislation, it's consistently held that it needs to be interpreted very restrictively, since it does restrict the rights of others under human rights legislation. The divisional court also emphasized that an employer who wants to rely on a bona fide occupational qualification exception under human rights legislation must prove a direct and substantial relationship between the specific job's qualifications and the abilities and qualities needed to satisfactorily perform that particular job. So in this case, the appeal was allowed in part. The damages awarded to the complainant were maintained, but the court did vary some of the public interest remedies that had been ordered by the tribunal because they were deemed to be overly broad. And I will throw it over to Erin now. Thank you.
Thanks, Rhonda. Hi, everyone. I'm going to be talking about investigating discrimination and harassment. And while the purpose of the presentation is not to provide a comprehensive conducting workplace investigation presentation, we did want to highlight some of the considerations for conducting investigations when the allegations being made relate to the 2S LGBTQ+ employees. Some of the slides used in this section have been repurposed from a presentation that was previously done by one of my partners, Shane Todd, and one of our occupational health and safety consultants, Kathy Chandler. So I thank them for their generosity in allowing me to steal. So on this slide, you can see that there are several different reasons and overlapping reasons that require an employer to investigate allegations of harassment. Both human rights legislation and occupational health and safety legislation require that employers provide a workplace that is free from harassment and discrimination. Yet, Statistics Canada reported that in 2020, 1 in 4 women and 1 in 6 men reported having personally experienced inappropriate sexualized behaviors in their workplace during the previous year. All workplaces in Canada must comply with anti-harassment and discrimination laws and put policies in place to address inappropriate sexualized behaviors in the workplace, including procedures for reporting incidents to the appropriate people. Nevertheless, approximately 1/3 of women and 1/4 of men say that they have not received any information from their employer on how to report sexual harassment or sexual assault. 1 in 10 women personally experience workplace discrimination based on gender or gender identity or sexual orientation, compared with less than 1 in 20 men. Women, young employees, those with disabilities, or those belonging to the 2S LGBTQIA+ communities have personally experienced this kind of behavior on a disproportionate level. So almost half, or 47% of 2S LGBTQIA+ communities or workers have personally experienced this kind of behavior or discrimination, compared to just over 1/5 of the non-LGBTQ+ community. Almost a quarter of LGBTQ workers have been targeted with discrimination based on actual or perceived gender or sexual orientation, versus only 7% of the non-LGBTQ+ community. Specifically, many were told that they do not act how someone of their gender is supposed to act, almost 15%, and were insulted, mistreated, ignored, or excluded in the workplace because of their gender, 11%, or sexual orientation, 9%. So what's made clear from all of these statistics is that although there is a requirement for employers to provide a workplace that is free from discrimination and harassment, this is still a problem. And this problem is only compounded for those in the LGBTQ plus community. Andrea, if we can go to the next slide, please. Thanks. So in every Canadian jurisdiction, employers have an obligation to provide employees with a workplace that is free from harassment and discrimination based on protected grounds. As Jake mentioned, gender expression, gender identity, sexual orientation, family status, and marital status are all protected. Most of the legislation across Canada will define harassment. Most of the human rights legislation will define harassment. And Jake also set out some of the court's reasoning on defining discrimination. As such, as an employer, if you receive a complaint, and it doesn't have to be a formal or a written complaint, you have an obligation to investigate those allegations. Similarly, under the occupational health and safety legislation, employers have similar responsibilities and duties. As outlined on the next slide, the various provincial and federal legislation requires that employers take all reasonable precautions to ensure that employees are safe at work. This means creating an environment where there is a culture of respect and people feel safe. There is an obligation to have anti-harassment and anti-violence policies. And employers must be able to access this, employees must be able to access this policy, be trained on it, and understand their responsibilities. There must be a way to make complaints with an alternate format for situations where the complaint is being made about the person that the complainant would normally report to. Complaints must be investigated in a timely manner and appropriate for the circumstances. Employers must issue findings or write a report. Employees have a right to know the outcome of the investigation. For example, in Ontario specifically, workers have a right, both the complainant and the respondent have a right to be informed in writing of the results of an investigation. That assumes that the respondent is in fact an employee of the company. On the next slide, we've included definitions of harassment in the legislation, occupational health and safety legislation across Canada. As with the human rights legislation, often the definition of harassment is explicitly stated. Many of the definitions indicate that harassment can be either a single incident, typically those would be more serious in nature, or a series of incidents over a course of time. Regardless of whether or not the legislation specifically allows for one single incident to result in a finding of harassment, the case law makes clear that single incidents in and of themselves can be sufficient. It's also important to remember that harassment can occur outside of the four walls of a workplace as well. So employers have an obligation to ensure that their employees are protected, as outlined on the next slide, when incidents occur off the employer's premises. So for example, incidents that happen at company events, holiday parties, business trips, conferences, all of those could be protected under health and safety legislation because it would be considered that the employee is still acting in the course of their employment. Similarly, incidents that occur outside of the workplace or outside of working hours would be captured by the legislation. This is particularly true as we examine social media and the impact that social media has on today's society. The 2S LGBTQIA+ community is more likely than heterosexuals to receive online harassment. So the statistics indicated that it was 37% versus 15%. So, and when it comes to the experience of inappropriate behaviors while online, the 2S LGBTQIA+ community were more likely to report that they knew the person who had targeted them in the harassment. Many of those indicated that the harassment stemmed from the workplace. The 2S LGBTQIA+ community is also more likely to have taken measures to protect themselves from online harassment in the past 12 months. So that's 38% versus 23%. So it's clear that the employer's obligations, and you have to be sensitive around what is occurring online. And then finally, an employer could also have responsibility, or would also have responsibility, for incidents that occur between an employee and a third party while the employee is at work. So you have a responsibility to ensure that your employees are being treated with respect and feel safe within the workplace when they're dealing with customers, consultants, contractors, delivery people, and any outside vendors. The consequences for failing to investigate can be severe. We've outlined several of the different areas that or consequences you could face if you fail to investigate or appropriately investigate allegations of harassment and discrimination. And while it's clear that failing to conduct investigations can cost money, as indicated above or on the slide, it can also create an environment where employees do not have trust in their company or believe that their company is there to protect them. We've indicated, therefore, that there are some things that you should consider, and particularly consider when conducting an investigation into allegations of harassment and discrimination based on the LGBTQ+ community. First, it's important to ensure confidentiality. While confidentiality is always essential for an investigation, you may need to be particularly careful in these cases. Some employees may not be out. You do not want them to out them in the course of your investigation. Think about how you can ensure that you're able to ask the questions that you need to without putting people in a place where they're either outing themselves or others within the workplace. You also want to ensure that documents are securely stored and only those who need to have access would have access to them. You should also consider what the effects of your investigation could be, such that will this become the subject of a grievance procedure or potentially a wrongful dismissal or human rights complaint. Again, these are public documents, so you could be inadvertently outing someone through the course of your investigation. Second, you want to consider whether interim protections are needed. So often this could result in somebody being placed on a leave of absence. Sometimes employers put the complainant off on a leave of absence rather than asking the respondent to go off on the leave. So you should consider whether or not this is appropriate, or if it could be viewed as an instance where you're actually discriminating against or disciplining the person who brought forward the complaint. You also want to consider your own biases. I have a slide on that next that goes into that in a little bit more detail. You should offer the complainant support through either your EAP program, access to benefits, or other community resources. As we'll discuss in a moment, being part of an investigation like this can lead to a trauma result or a trauma response from some employees, and you just want to be sensitive to that. And finally, you should also consider whether it's appropriate to call the police. There may be instances of hate crimes or harassment, assaults that should be reported to the police, but you also want to have that discussion with the complainant to determine whether or not they're comfortable and whether or not they wish to pursue those matters. On the next slide, we talk about some of the different biases or things to keep in mind when you're thinking about bias. We all have them. They stem from our personal experiences, what we hear from others, our upbringing. What we need to do is recognize them and be honest with ourselves when we're investigating situations like this. Could your bias have an influence over the investigation? And if so, what steps can you take to try and mitigate that? So the role of the investigator is an important one, and it's difficult sometimes in situations like this because you're dealing with very sensitive matters and things that are very personal to people. And so it's, you can naturally would become invested in the investigation and the conclusion of the investigation. But we need to remember that we are there in a role as an investigator, and we're not clinicians, psychologists, doctors, or anything of the sort. We need to offer support to our employees through other providers and not provide that support, particularly any sort of emotional or psychological support. We should encourage people to seek outside assistance if they need it and make it available to them. And you need to remember what your role is in the investigation. So you want to gather the evidence and review it and be impartial to the facts. How you conduct yourself in the investigation and with all the parties has a direct impact on the quality of the information received, and thus ultimately the accuracy of the investigation's outcome and the follow-up or recommendations provided. I'd like to take a few moments to acknowledge the role that trauma can play during an investigation like this. Trauma is a term used to describe the challenging emotional consequences that living through a distressing event can have for an individual. Traumatic events can be difficult to define because the same event may be more traumatic for some than others. People from the LGBTQ plus community are more likely to have experienced trauma in their lifetime. Statistics indicate that they are double the risk for PSTD, that the LGBT plus community youth are 14 times more likely to consider suicide. 77% of trans people have considered suicide, while 45% have attempted it. And hate crimes, as mentioned earlier by Grace, against the LGBT2 plus community have dramatically increased over the past couple of years. So it's safe to assume that individuals from these communities are coming to work with trauma. You don't leave your trauma at home. And as an investigator, you want to be sensitive to that and to the impact that that can have on your investigation. There is a quote on the next slide from a book by Jeffrey Nolan, an article, Fair, Equitable, Trauma-Informed Investigation Trainings. So, and here there is a discussion about what investigators need to know and to come to investigations with an understanding of trauma. And without that understanding, the potential effect that trauma can have are sometimes misperceived as attempts to be evasive or to falsify information, because people may not be able to give a clear recitation of the facts in a chronological order. They may seem mixed up or confused about certain incidents, and that may not be because of a lack of credibility. That could be influenced by the past and past traumatic events by the person being investigated. And so you just have to be aware of that and the impact that that can play, and you know, check that assumption when making traditional findings of credibility of your different witnesses. We've offered a couple of tips to keep in mind when doing a trauma-informed investigation. The first one is with the pre-interview. So participant safety is key. You want to ensure that those that you're investigating feel comfortable. And one of the ways that you can do this is by offering them a neutral location to conduct the investigation. This may be more difficult in a situation where you're doing it by Zoom. So they may be able to find a place on their own, or they may be in shared space, depending on what their circumstances are. So trying to be as sensitive to that as possible. And also offering them choice. So choice in time to meet, where to meet, if you're doing it in person, where to sit in a room. All of those things can show that the complainant or the witness who's coming forward has some control over the situation. At the beginning of the investigation, you want to be transparent about your purposes and what your plan for the investigation is. How long will it take? When do you expect to have outcomes? Will this person hear from you again? If they're a witness, they may not. They may only provide their information and then would not have any sort of information about how an investigation concluded. Whereas if they're the complainant, then they will be informed of the results at the end of the investigation. So they should be made aware of these things up front. Third, you want to ask trauma-informed questions. So again, this gives the person who's telling the story control over the narrative. So rather than being focused on a chronological order, In your questioning, you can ask people, begin where you feel comfortable. Tell me more about that. Help me understand. You may need to throw away kind of your set of questions that you have when conducting an investigation. And you may also need to spend a little bit more time at the beginning conducting or asking some questions to ensure that you build a rapport with individuals so that they feel that there's some level of trust. And then finally, in closing the interview, you want to demonstrate empathy towards the person who came forward, recognizing that it's probably been very difficult for them to bring forward this complaint, and also difficult, because of sometimes the nature of the complaint, and it means that it impacts not just them, but other people. Again, you want to be able to offer them some sort of support, whether it's through EAP, community supports, or access to benefits. And you also want to give them an opportunity to come back to you if they have further information or if they think of anything that they didn't talk about. You should give them an opportunity during the investigation to say, have I missed anything? Is there anything of significance I should know? So that you are sure that you've been able to capture their entire story, and that it doesn't end when you think it should end, but rather when the complainant is able to come forward and tell their story. So with that, I will pass it back to Grace and Jake, who will talk about the lived experience in the workplace and offer some recommendations.
Thanks so much, Erin. So just looking at the time here, we're running a little short, but there are many different things to consider when thinking about the 2S LGBTQIA experience and how we can better shape our workplaces and ways to do that. And so, Grace, would you like to take it away with policies that could be put in place?
Thanks, Jake. So in terms of policies, you want to review your existing policies and identify any gaps. So this includes conducting a review for gender inclusive language. This might involve dress codes. Do your dress code say men are meant to wear this, women are meant to wear skirts, so on and so forth, right? So recognizing that different forms of gender expression that we discussed before is important to de-emphasize gender and remove gender terminology. So just using, professional attire includes as follows, making it a list, not just including the binary, the male and the female. As well, including terminology in your policies day-to-day in the office or on-site for all employees can use the bathrooms or washrooms that they most identify with. That's a key one. And so, codifying that in a policy of types is important. As well, gender affirming decision-making policies, often referred as transition policies. Just policies that can set out the steps in support of information and even resources that employees who are taking any gender affirming steps, doesn't need to be, transition or transitory in any way, just any gender affirming steps can look to for best supports.
Yeah, and I think the next bullet point, administrative review, looking at just kind of the mundane everyday type templates that one might have. So whether that's a letter or a business card, and just thinking about the ways that template can be more inclusive, considering using pronouns at the end of email signatures or name tags in office doors. Business cards is a great one. Again, a great way to start that conversation. And if it feels awkward, then that's a good icebreaker. And then precedents, the letters that say, dear sir or madam, perhaps make that more generic, refer to the person's name or how they are styled in prior communications.
As well, in terms of physical office space, so just providing the option for gender neutral washrooms. There can be different complications with this aspect in terms of having a landlord that's responsible for your building, but opening up that discussion with your building landlord, your office manager, and even communicating that to employees. We're looking into this. We're trying to determine on-site, off-site, work site, where you are going to be most comfortable in the physical space. And Jake mentioned the importance of that comfort earlier on in his presentation as well. And then just in terms of, space generally, give space to meet and to create affinity groups with support. So if your employees want to start a 2S LGBTQIA plus affinity group, support group, social group, anything of the nature, provide that office space, provide that setting for them, which will just include and make the space more inclusive and positive.
And if we could go to the next slide, there's also existing employee education and engagement. And I touched on this a little bit earlier, but there are opportunities to inform people through different lunch and learns by having HR professionals come in and do some discussions, or also just having a more fun presentation or different pride events throughout the workplace, I think is a great way to engage the workforce and also have an educational component to it. And then also finding high points of contact and providing educational support to those people. So receptionists, IT, HR professionals, management, these folks can really be leaders and help other employees learn and take a more proactive approach in the workplace.
And in terms of new employee intake processes, you want to consider including a brief overview of your policies, of your resources during that orientation time, providing, links, paper copies, as it can be a bit of an overwhelming time starting someplace new, including information about workplace affinity groups, opportunities to celebrate. It shouldn't just be informative in the sense of here's what happens if something goes wrong, right? It should be here's what we do. Here's, you've already accepted employment with us, but here's all these other things that we're doing. We want to celebrate pride. This is the timing we do that. This is how we participate. These are, who we contribute to, our sponsors. We value our relationships. We look into who we want to partner with. All this information, it is helpful in setting that tone and creating that environment. Recognizing special events like today, which I will mention at the end. And it also, provides, as Jake was mentioning, certain points of contact, putting a name to a face in terms of, these are the people you can especially turn to in the community. Whether or not they're a member of the community or not, it doesn't matter, right? It's just about creating that positive space.
And I think finally, all of this creates a positive culture and an environment to work in. And there are many ways to do that. As Grace alluded to, there are affinity groups. Fasken has multiple of them, including the Pride Network, which is pretty active. There's also EDI surveys and data intake. And again, I think those can be helpful from a metric standpoint, but doesn't always capture the lived experiences or substantive experiences. It's just a metric, right? It's just a number or a box. So something to consider when thinking about EDI surveys is to how inclusive can they be, and are we really doing the most for equity seeking groups by collecting that information, and what do we do with that information? I think that's the most important kind of idea around surveys and data collection. And then just looking at partnerships, public and private, and again, the whole idea of Erin's presentation on investigations is people who feel safe will report incidents. People who don't feel safe may not report and come forward. And you want to ensure that everyone feels safe to come forward to report complaints and incidents so that they can be investigated and employers can have met their obligations under the code, but also just have a safe and welcoming environment. So with that, we are going to move to our next portion, which is the question and discussion period. And there are quite a few questions already in the chat. So thank you, everyone. The first we will address is a question regarding pay equity. And so that really could be a presentation all to itself, maybe 6 presentations, because the legislation is very complex and dedicated. And so we will be circulating a link with some articles on pay equity so that people can get a little bit more information, as well as, please stay tuned for some other Fasken presentations in the future. We also have another question for the group, and maybe I'll turn this over to Erin in investigations. We have regarding the question about contacting police. Do we have an obligation to go to police if we think the law has been broken within our workplace, instead of asking the employee permission if we can contact the police? What are our responsibilities?
Yeah, so generally, as a general rule, you don't have an obligation to report crimes to the police. So, that's a starting point, is that that's not a requirement. And if you have a complainant who comes forward who does not wish to involve the police, then I think it only in the exceptional case would you go around them and their wishes and report to the police anyway. And one of those circumstances would be, if you thought that there was a current or ongoing threat to someone's physical safety. If you have that belief, then I think that you would have an obligation to reach out and inform the police. But otherwise, somebody who's come forward and reported being the victim of an assault or ongoing harassment, to take away that right and then force them to interact with the police when they may have experiences with the police that haven't been positive, or they may have their own trauma in their background. I wouldn't want to take that decision away from them. So, it's the great lawyer answer. It's going to depend on the situation, but generally, I would leave that to the complainant to decide.
Thanks, Erin. We have another question. How do you deal with barriers and obstacles coming from senior leadership in making an organization more visible to support LGBTQS initiatives? Grace or Rhonda?
I'm happy to take this one. I think it all starts with us recognizing the individual impact that we can have. So regardless of our job title, whether we're in senior leadership or not, setting that tone of just saying, this is what I'm going to do. And, I'm going to attend Pride this weekend. If anyone wants to come join with me, that would be lovely. So I think in setting that tone, in making yourself, whether you're an ally or not, but especially if you're an ally, of making yourself a safe space, a safe haven for open communication, open dialogue, especially, as I mentioned at the beginning, if you're saying, we're all learning, I'm learning, I want to get it right. And I think in terms of, directly speaking to senior leadership, there's lots of resources out there in terms of numbers, in terms of the economics of diversity, in terms of how diverse workplaces benefit all of us. So whether you have one person that from the LGBTQ2SI+ community in your workplace, or 100, it should be the same level of effort in creating that safe space, as well as we've all discussed today the legal obligations in doing so. So I think in just sharing that educational information and sharing those resources, in addition to it being the right thing to do, to start chipping away at those historical and societal prejudices, which we're all born into. We're all learning, as I mentioned. So I think that's just the key, and so start with your own impact as an ally, as a member of the community, and really try to push forward on that.
Rhonda or Erin?
I guess I would just add that we often think in terms of grand gestures to slowly make change in an organization. And the way I think about it is that you don't need to make grand gestures. Sometimes it's, oftentimes I think it's what could be considered to be small changes, ways of speaking, ways of addressing inappropriate behavior in the workplace, that over time have a cumulative effect and create a shift in what's acceptable and not acceptable on a grand scale in an organization. So I would encourage everyone to think in terms of daily micro level changes rather than on a macro level, because I think that the cumulative effect really over time can cause great shifts.
And I think that dovetails nicely to the next question, where we have an audience participant. To the extent to which we can talk about a person's sexual orientation, to what extent can a person be asked to identify themselves related to equity, diversity, and inclusion? And do we have accommodation obligations? I guess I'll take the first crack at this one. I think it's important to allow people to talk about what they want to talk about and feel comfortable talking about from themselves. So making a safe space for people to talk about it, but not necessarily being the one to bring it up. As Erin mentioned, everyone's at different stages in their comfort and how they want to identify in the workplace. Some people are closeted fully, some people are closeted to their family, but out in public, and others are in different forms of questioning within that. So I think it's more of a sense of support rather than thinking of it as an accommodation, like a medical accommodation. It's more so letting people come to you and ensuring that there's a safe space for people to express themselves. But happy to chat on this one because it seems like many different ways to think about it.
And Jake, I'll just jump in to add that I think a lot of companies are looking to collect EDI information if they don't do so already, and looking to see whether or not they can ask employees to self-identify in surveys either at the time of hire or thereafter. And I think that you can do that, but with proper considerations, privacy considerations and things like that. But I think you also want to both think about the reason why you would ask that. Like, why is it important to you to know what someone's sexual orientation is or what their gender identity is? Certainly it needs to be more than just for your curiosity. It should be more than just for collecting statistics. So you should actually have a reason for asking that information. And then on any survey that you would send out or any questionnaire or things like that, you should also, you can make it mandatory to complete the survey, but then make it voluntary basically to answer every single question thereafter. So, every single question that you ask about when you're collecting EDI information should have, I prefer not to answer, unless, you're part of a federal work program where you need to collect some information about equity for that. But otherwise, you really should offer people the opportunity not to answer.
We also have another question that just came in, which is an interesting question. If an employee has been harassed outside of work and work hours due to their orientation by a coworker, what can we do as an employer, and can we discipline at work? Rhonda, would you like to, or Erin?
Yep. So I'm. Oh.
Go ahead, Erin.
Okay, so as I had mentioned, that employers could have an obligation to sort of marshal or behavior that occurs outside of the workplace. Typically, this is for actions that would be, although it's not on work property, it would still be considered to be in the course of employment. And if it's two people that know each other, or interact with each other completely outside of work, and it has nothing to do with work, then you may not have much that you can do about it, unless it gets to the point where that person no longer feels safe to come into the workplace, or that they feel that behavior is spilling over into the workplace, which it could very well be, and in many cases would likely to be, because how can someone be treated in one manner outside of the work and then in a different way inside of the workplace? So although we can't be, as employers, we can't be our employees' keepers, so we can't monitor what they do and what they say and what they think at all times, I think you just have to be conscious of what is the impact that's having when it comes back into the workplace, and how your employees feel in those circumstances.
And to feed off of what Erin was saying, I was going to add that a lot of these things are contextual So we want to look at what the nexus is between, the workplace and the behavior that occurred outside of the workplace. And it could also be worthwhile to take a look, another look at your policies, your anti-harassment and violence policy that you've got in place, your social media policies, and see how we define the workplace. So we want to be sure that employees understand that the workplace is not limited to the physical premises or necessarily work hours. Like Erin mentioned, there could be workplace events that happen off hours, off premises that would still be, where the conduct would still be captured by that policy. So we want to ensure that employees understand that, our policy has a broad application, and then look at, every situation of, workplace or conduct that occurs outside of the workplace or off hours, and see if there is a tie-in to, a reasonable tie-in to employment or to how the victim could, feel as far as the work environment, and, whether there's a level of conduct that would go against the policy that we want to apply in the workplace.
Thanks, Rhonda. I think that we're out of time for today. So to end, I'd just like to note that today is International Day Against Homophobia, Transphobia, and Biphobia. And I think as we've learned today, education may not completely disarm prejudice, but it's a good place to start. Thank you all for joining us today, and to my fellow speakers as well. A reminder to please fill in the survey if you haven't done so already. We do read your feedback. Our next webinar is coming up on June 14th on the topic of recent immigration updates, what employers need to know. Please visit the Fasken Institute section of fasken.com to register. I hope you all have a delightful day.